Hi guys, welcome to LawPutra YouTube channel. My name is Advocate Govinda Narwani and today's topic is what is the principle behind asking leading question. Before we move on to this topic, I would like to discuss about leading question. Section 141 of Evidence Act has defined leading question. Now, let us see what does section 141 say. Leading questions are the questions which suggest the answer in the question itself. For example, a question in a courtroom to a witness is asked as follows. When did you see A killing B? Now, here in the question itself it is suggested that A has killed B. Right. So these types of question which has answer in itself are leading questions. Now let us discuss about these leading questions, whether they are permitted, prohibited or somewhat permitted. So now section 142 states that when leading question must not be asked. So it clearly states that while a witness is under chief examination, he must not be asked leading questions. So, is this completely true or there are certain exceptions to it? Now, in certain cases, when the facts are introductory or they are undisputed or such facts have been sufficiently proved already, in such cases, the Honorable Court may permit you to ask leading questions. Apart from this, there is no situation you may be permitted to ask leading questions. Now let us move on to section 143. When they may be asked. Section 143 of Evidence Act says that when leading questions may be asked. So it clearly states that when a witness is under cross-examination, he may be asked leading questions. Now, I would like to highlight one more situation under section 154. Section 154 deals regarding hostile witness. It clearly does not say hostile witness, but the section reads as question by the party to his own witness. Now suppose a person is being called into the court to give a testimony by a party. While giving such testimony, he has made some adverse statements or behaved hostile against the person who had called him. In this situation, the person who is examining him in chief obtains a permission from the court and then treats this witness as hostile. After the permission is granted, now in such situation, he may be allowed to put questions to such witness, and during these questions he is also allowed to ask leading questions as such witness has behaved adversely against him. Why such leading questions are to be allowed? If we think logically, we can deduce certain conclusions. Now, what are these conclusions? The person already beforehand knows what such witness is going to say and what he is going to deny. Therefore, it is already known to that person what he is going to prove and what he is not. Therefore, to balance this type of situation, leading question is allowed to the person conducting cross-examination. Now, how leading question is beneficial to the person conducting cross-examination? While conducting such cross-examination, leading questions are asked by the concerned advocate so as to bring the witness on the path which the concerned advocate has a bearing in his mind, while making him travel to that path and finally making him placed at a certain position where his credibility is damaged or certain admissions in the favor of the person conducting cross-examination are attained. Now, to highlight the importance of leading questions during cross examination, let us study a landmark judgment of Lata Prasanna versus Inspector General of Police 1953 of Honorable Allahabad High Court. The facts of this case are that a police officer during an inquiry was not allowed to ask leading question during cross examination, and thereafter his services were terminated. He challenged the order of his dismissal before the Honorable High Court of Allahabad by filing a writ petition. It was noted by the Honorable Court that why asking leading question during cross-examination is important and the principle behind it. And it was laid as follows. Leading questions are asked to check the accuracy, credibility and general value of the evidence. Further, to shift the facts already stated by the witness. Further, to elicit facts in the favor of the party conducting cross-examination. The Honorable Court also noted that leading question is an important weapon of the person conducting cross-examination, and if such right is denied, it would result into grave injustice. Therefore, through this art of cross-examination, a person is asked leading question, and finally, the object of cross-examination is attained through asking leading questions as discussed above. Now, I conclude my topic and thank you all for your support.